Hi, this is Steve Dale. I'm really excited here about our presentation today, and we'll go through a little bit here about our presenter. We are recording this on October 21st, 2020. For those of you who may be watching this years in the future, we are going through this little thing called COVID here. And so we don't know if we're midway through this. We don't know what's going on with this, but we certainly know that this has been affecting us here. Just going through what we're going to cover today and a little bit about our speaker here. And as I'm going to share with you, this is a very special subject for me for any number of reasons. Here we're going to be talking about housing protections for families with special needs children here. And our presenter is Celia McGuinness, who's a disability rights lawyer. She's a founder and partner at Derby, McGuinness, and Goldsmith. Is that correct? Did I miss somebody? Yep. Okay, there we go. That's here. And, you know, she's been a lifelong advocate, or at least from the time I've known her. I don't know what she did before I first met her here, for persons with disabilities, here with a special focus on accessibility issues and that sort of thing. You know, I could spend probably 10 minutes going through all the different things she's been on, but she served 2 terms here on the Disability Access Commission, or at least at the time this was written here. She's here has also here provides mediation services here with cases dealing with issues having to do with persons with disabilities. She serves on a standing committee on court rules and processes here. The law firm she's with, and I want to talk a little bit about the importance of these law firms before we turn this over to her, but they cover, they deal with a number of different issues, including housing discrimination. We were talking about this before, what's the proper term? In my days, it was called access law. Here, you can call it discrimination in the public sphere, whatever it is. We need somebody out there who's going to really enforce a lot of our accessibility laws and that kind of thing, and that's a lot of what her firm does. And she also deals with employment discrimination and that kind of thing. Now, what she doesn't do is she doesn't do benefits law, and so you can correct me here. She does do things around education, but she doesn't do, their firm does not do IEPs and that sort of thing.
That's right.
Okay. A little bit about this, and I'm going to be a little indulgent. For those of you that know my history, I started, got into this because I did internship work at the Disability Rights Education and Defense Fund with some of the greats here at the time. And this is something really important to me. And, you know, what it really impressed on me and really had a lot on my, directed my personal life and my professional life is really just looking at understanding not just the needs for accessibility in the community, but the fact that, you know, the government usually does not enforce these rules that have been on the books for a few years, as I understand it. And so if we did not have firms here like Derby, McGuinness, and Goldsmith, once again, a lot of the laws we have to do with accessibility and that sort of thing just would simply not be enforced. I think what these organizations, what these law firms do is incredibly important. And quite frankly, I think that we need to support the work that they do, because on occasion, and we could spend an hour on this, on occasion, we've had businesses, organizations, and that sort of thing who have really turned on what I would call the access attorneys, the folks who do this work. And once again, the way the law was set up, it was set up to have a civil remedy, partially so that people can serve as their own attorney generals and make sure that these rules are enforced. Accessibility is incredibly important here. And so that's something that I really take my hat off to you and your firm for the important work that you guys do. With that being said, this is we are offering MCLE credit under the state bar. This has been accredited for a unit here. Depending on how long we go, we may be able to grant a unit and a half. In order to do that, in order to put in for the credit, there's going to be 3 codes that Celia is going to read to us here, and you need to mark down those 3 codes and put it on our MCLE application sheet, which you can find at gspt.org. Go to Attorney Resources here and look for the information about MCLE programs. And at the very bottom, you can actually download the form and fill it out. Now, if you can't find the form, you can find it by emailing Amy, AMY, at gspt.org. On top of that, if you would like to be on our mailing list for future programs here, the place to go at this point is send an email to amy at gspt.org, and we will be glad to put you on our mailing list. Celia, I am so excited about you presenting today, and I know this is very timely. So anyway, what do you have to tell us about housing protections for families with children with special needs?
Well, I could probably talk all day, but I am going to try in this webinar to stay very focused on just a very little background on the fair housing laws and what they cover, on how to make a request for changes that you need in policies or physical space, and what to do if your requests are denied by your landlord or the homeowners association. I'm also going to talk about some resources for experts who can help. But before I do that, and after thanking you, Steve, for the kind introduction, I want to acknowledge that, as Steve said, we are in a pandemic, and that's actually what inspired this webinar, because we're finding that people are living in their homes a lot differently than they used to. They're home more often. Their special needs children are home more often, and they're finding that the ways they were able to get by before might not be working now. So I want to thank our firm's paralegal, Shalisha Patrick, for her inspiration that led to this presentation, and let you know that I acknowledge and I'm grateful to all the parents of special needs children. I recognize how difficult your job is, and you should be proud of yourselves for the hard work that you put in on behalf of your children. And I'm hoping that with this webinar, I can help you in a small way. So this webinar is going to talk about the rights of people with disabilities. What I'm talking about applies to all people with disabilities, regardless of their age or where they fit into your family. But a lot of the examples I'm going to give are specifically focused on issues that arise for families that have special needs children. When we get to the questions at the end, I'm going to ask you to please put a question in at any time, but I'm going to answer them all at the end. I'm happy to answer questions that aren't really focused on children necessarily, but are about housing rights for people with disabilities. Okay. So, as I said before, we're going to talk about the tools you need to make sure that you and your family have equal access to and enjoyment of your homes. We're going to talk about how to document your requests for whatever accommodations you need. And I'm going to tell you several times, please ask for help early. Ask for help, and don't wait for an eviction notice or a problem to arise, because these are a lot easier to deal with if they're responded to sort of timely. All right, so people often refer to disability rights by using the term the ADA. And the Americans with Disabilities Act does, of course, protect people with disabilities. There are a panoply, though, of laws that protect people with disabilities in addition to the ADA. I can think of at least 6 off the top of my head. And they apply in a range of circumstances, and they can overlap. But today, for these purposes, we're going to refer to them as the fair housing laws, because we're focused on the laws that protect the right of equal housing for people with disabilities. So as part of the background that we need to know is we need to know how a disability is defined. And all of these laws define them in essentially the same way: a physical or mental impairment or condition that substantially limits a major life activity. That is intended to be very broad. You are a person with a disability if you currently have a disability, if you have a record of having a disability, or if someone perceives you or regards you as having a disability, whether or not you actually do. So people who have intermittent disabilities, where sometimes they're symptomatic, sometimes they're not, they're people with disabilities. People who are temporarily disabled because, I don't know, they broke their leg in a skiing accident, that person qualifies as a person with a disability. So the purpose and the congressional and state legislative intent is that we have a very broad umbrella for people with disabilities. And here, just briefly, are some examples of disabilities. And the first one on my list here is visual disabilities, which reminds me to say that for people who are participating in this webinar or who see it when it is recorded later, I am going to speak what is on every slide. And if there is a picture or a photograph in a slide, I'm going to describe that. And sometimes that throws people who don't have visual disabilities off a little bit because they're not used to it. But this is sort of an easy way to accommodate people with different abilities in the course of this webinar. So some of the examples of disabilities that are covered by the fair housing laws include visual disabilities, auditory disabilities, mobility disabilities, which is what a lot of people think of, I think. Medical conditions such as AIDS and HIV, diabetes, cancer, someone who's had a stroke, arthritis, chemical sensitivities, people with intellectual or developmental disabilities. If you have a history of substance abuse or addiction, if you have a temporary disability, or if you have a mental health disability, this is a list is not comprehensive of the kinds of disabilities that are covered. The focus on this in this webinar is that discrimination harms the whole family. If a person with a disability cannot live comfortably and equally in their home, it's going to have an impact on the family. And the reason I'm highlighting this is that the fair housing laws also protect people who are not disabled, but have a relationship or an association with a person with a disability. It's called associational standing in the legal jargon. And what that says is if you have a relationship with a person with a disability, they're discriminated against, and that discrimination has a direct harm against you, you also have standing to enforce the fair housing laws on behalf of the person with the disability and on your own behalf. So this is a very useful part of the tool because it doesn't require a child to participate in a lawsuit or to be a plaintiff in order to get a remedy. The lead case on this that all the lawyers know is a case where a family wanted to go watch their grandson play football, and they wanted to bring their granddaughter with them. She used a wheelchair, and there was no paved path of travel to get to the football field. So Grandpa had to carry her in his arms across the field, and Grandma had to push the empty wheelchair. And the court ruled that Grandpa had standing to sue in order to get an accessible path of travel for the wheelchair, because he had been directly harmed by having to, carry his granddaughter, experience the weight, and have this this barrier that was put in his path as well as in his daughter's path. Another case I've had is I had a service dog case where a woman was put in a locked psychiatric ward and they would not allow her to bring her service dog with her into the ward. That was a violation of her rights as a disabled person. She had the right to have her service dog in the locked psychiatric ward. But we also sued on behalf of the husband, because as a result of them excluding the service dog, he had to travel back and forth to the locked psychiatric ward to bring her the dog, and there were a lot of other problems that eventuated for him as a result of that. And then there's a case I have right now with a single dad whose son uses a wheelchair, and his apartment complex is not enforcing the parking laws. So people are always parking in the van accessible crosshatch space. When they do that, he can't open his van and get his son in and out of the wheelchair van. And so I did not sue on behalf of the son, who is a minor. I sued on behalf of dad because of the direct harm that the apartment complex's policies are causing to dad. So who has to comply with these fair housing laws? Well, it's a very, very broad group of people. Landlords, housing authorities, group homes, property managers, homeowners and condo owners associations. It does not only apply to people who rent, it applies to people who own and are subject to some sort of entity's rules. The only real exception to the fair housing laws is private owners of single family homes who aren't renting them as a business. But even in that situation, some state fair housing laws will still apply. And the fair housing laws also may cover conduct by other tenants or neighbors that are discriminatory. So just to emphasize, some of you who are watching this may have older children or children who are not living at home. If you have, this slide says, what about a problem with my group home or my college dorm? Is that an ADA problem or a fair housing problem? And the answer is, I'm really glad you asked. Group homes and college dorms could be subject to both the ADA and the fair housing laws. But the important thing to remember when approaching the needs of a person with a disability is to focus on not so much what statute applies, but do I have a need related to my disability? And then we refer to that as the nexus. As long as there is a nexus between your disability and your housing related need, that is going to be covered by this whole panoply of laws. Disability-based discrimination can take a lot of forms. We don't very often see people, a landlord who will walk up to a person and say, I hate people with disabilities, I'm going to discriminate against you. It happens. But what we most often see is harmful impacts of a supposedly neutral policy. So if there is a rule, for instance, that this has happened now, there's a community rule that during the day, only adults are allowed to use the swimming pool. And that hasn't been a problem for a family because their children are at school during the day and their children have physical therapy through the school. But now everybody's being educated at home, for better or for worse. And so they have to do their physical therapy at home, but they don't have access to the swimming pool, and it makes the most sense to do the PT in the pool. So a neutral policy saying no children can swim during the day actually has a discriminatory impact on a person with a disability, a child with a disability, and it needs to be modified. So this slide also lists unequal treatment, denial of housing opportunities, meaning someone saying you can't rent here because your disability, ensuring equal access to common areas, as I described, discriminatory advertising or other statements, which is somewhat rare, retaliation and harassment, which is unfortunately not uncommon, and the one that most people think about, which is failure to grant a reasonable accommodation request. So this slide has a big stop sign with some marks to show that it's being waved around, and it talks about prohibited practices. So this sort of reiterates how broad the scope of potential discrimination is. Denying programs or services or benefits based on disability, providing only separate or segregated programs, using eligibility criteria that tends to screen out people with disabilities. For instance, prohibiting not wanting to rent to somebody who gets disability benefits. Asking unnecessary questions about disability is a form of discrimination. Imposing extra charges, and again, retaliation. These are all different kinds. So for instance, if a landlord or a homeowners association doesn't allow vans in the parking garage, even though there's sufficient clearance, or if they require you to show, if somebody requires you to show a driver's license to cash a check and you don't drive because of your disability. The exception would be if there is a rule that is necessary for safety. For instance, if you want to participate in this rafting expedition, you need to know how to swim, that kind of thing. It's also illegal to charge for disability-related services. So if a sign language interpreter is needed, the person with a disability cannot be charged with that. If a person with a disability needs their building security to bring packages up to the apartment because they can't leave their apartment or because they can't get access to the mailroom, they cannot be charged for that extra service. So what the law says is that housing providers have an affirmative duty to be flexible in their rules, policies, practices, and procedures when necessary to provide equal access to housing for individuals with disabilities. In this presentation, you're going to hear me use the phrase reasonable accommodation, and we're going to hear me use the phrase reasonable modification. Technically, a reasonable accommodation is a change to a policy or practice, and a reasonable modification is a change to the physical structure of the building. But many people refer to them jointly by the term reasonable accommodations, and I sometimes will do that myself unless it's necessary to be more specific. All right, so here we are. For those of you who are attorneys and are watching this for credit, this is the first MCLE code. The number is 8799. 8799. And this slide also states that the program is accredited by the Golden State Pool Trust and by the State Bar for 1 unit of MCLE credit, and it gives the website where you can download the form. 8799. Okay, so let's talk about some examples of reasonable accommodations in rules, policies, practices, and procedures. A very common one is a person who has a disability may not by themselves qualify financially for to lease a unit because they just don't have sufficient income. It is absolutely permissible to allow a co-signer to the lease to guarantee the rent. It is permissible to adjust a rental due date because if a person's disability benefits come in on, say, the 10th of the month usually, but your rent is usually due on the 1st, that causes a real problem. The landlord should adjust the rental due date. Flexibility in any program rules that are not burdensome, and we'll go into what burdensome means a little bit later. Any modification that addresses hoarding problems for people who have a hard time keeping their spaces clean. Live-in aids, if a unit is zoned for only one person, but somebody needs a live-in aid, or if they need a larger unit than they would otherwise qualify for because of their live-in aids, all those modifications need to be made. Even evictions can be delayed or sometimes dismissed if it's necessary to provide equal access to housing for a person with a disability. And of course, like I mentioned, changing common area rules. So I have 2 examples of that from my cases. One, prohibiting an exterior, a condo owners association that prohibited anything being attached to a building, and someone who, because of their disability, needed an air conditioning unit. the condo owner association has to modify their policy to allow that exception to the prohibition against putting things on the outside of the building. If there are parking rules like 10-minute loading and unloading, but a person with a disability needs longer or needs an assigned parking place, that is absolutely something that should be commonly and easily granted. Modifications to housing, to the physical changes to the unit, these qualify as reasonable modifications. And before I skipped forward to that slide to let you know I'm going to get to a definition of that, but I want to just sort of give you some examples. A therapist or a provider may suggest to a family that has a child on the autism spectrum disorder that maybe they should install additional equipment, extra locks on doors, safety guards on windows, because the child is an escape artist. All of those things are called reasonable modifications if they require an actual change to the building. They're reasonable accommodations if it really just requires a policy change. So a reasonable modification, although it's a physical change, it doesn't include repairs. So if there is part of the facility that would be accessible except the landlord's not maintaining it, that can be a kind of discrimination. If there's an automatic door opener, for instance, on a building, but it keeps breaking down, the failure to maintain that accessible feature is a violation, but it's not considered a reasonable modification. It's considered a reasonable accommodation of the maintenance policy. Some of these changes, some of these distinctions that I'm making are slicing pretty thin. And it's really not necessary for you to understand the difference between an accommodation and a modification, except to the extent that a landlord might ask a person to pay for an accommodation. And here's the rule. The modification, the request for a physical modification to a unit must be granted if it's necessary to allow a person full enjoyment of the premises. But many times the tenant or the homeowner will have to pay for the physical modification. The landlord has to allow them to do it. There are a large number of exceptions to this rule. The landlord has to pay for the modification if the housing gets federal funding. So if it's obviously public housing, if it's a USDA, project-based Section 8 where the whole building is a Section 8 building. There are some acronyms. HOME is an acronym for public housing, community development block grants. Section 202 and 811, supportive housing for elderly or people with disabilities. There's a whole range of federal programs that when the landlord accepts the federal money, they are also accepting the obligation to pay for physical modifications to the building. If you have a Section 8 voucher or the building was built with California tax credits, those do not trigger the landlord's obligation to pay for physical changes to the building. So this is an emerging area of law because it doesn't seem quite fair that a tenant should have to pay for a change to the physical property, which is actually a capital investment and improves the building, right? So there are a lot of lawyers, my firm included, who are trying to expand the definition of an accommodation, narrow the definition of a modification to ensure that landlords really do have to pay for improvements that are necessary for access. So it's our position, and we've won some cases on this, that the landlord should be required to pay for a physical change when the modification is needed for access to common use facilities. In other words, if there's a pool for the facility and the only way to reach it is by stairs, the landlord should have to put in the ramp, not the tenant with a disability, because the landlord is responsible for creating access to common area facilities. So another case that I recently concluded was there was a great big apartment building and all the doors were really heavy. And our argument was, and we eventually prevailed, that the landlord is responsible for making sure that the doors are not too heavy to open. And if the landlord can't put in a sufficient maintenance policy to keep them the right way, then the landlord has to install the automatic door opener. This is not an obligation of an individual tenant. Okay. So here are some examples of structural alterations with my legal opinion about who has to pay for them. If one easy distinction is to say, where is this change being made? So if the change is being made in the unit, like lowering or refiguring cabinets, replacing knobs on appliances, removing or adding flooring as appropriate for a tenant, adding grab bars or flashing doorbells for people with visual disabilities, that most often, unless it's a federally funded building, is going to be the obligation of the tenant to do. But the landlord has to grant permission for the tenant to do it. If the area of modification is in the common area, like widening exterior pathways for wheelchair users, taking out barriers in the parking area, modifying a parking spot so an accessible van can use it, or adjusting mail receptacles so they're low enough, those things should be on the landlord to pay for. So there are two things to think about this, and when you're approaching your landlord, and one is to be willing to be flexible if it's possible that there is an alternative to a physical change. For instance, in families where they have a child who's an escape artist and they are living on the 5th floor and they're concerned about their child jumping out the window, one solution is to put bars on the window or some sort of guard, and that's a physical modification. Another solution is to ask to be transferred to a 1st floor unit. And then the child is not going to fall if they come out of the window. So sometimes there are ways to work around the apparent expense of a modification by doing a policy change instead. The thing to remember, whenever you're about to approach your landlord or your homeowners association, your condo association, is that if it's not in writing, it doesn't exist. In order to get a change to a rule, policy, practice, or service, the tenant must request it. If you cannot assume that your landlord understands what your needs are, your family's needs are, if you have a person with a disability in your family, you have to affirmatively ask for what you need. So at this point, whether you want to call it a reasonable accommodation request or a reasonable modification request, I want us to talk about how to ask for a change to enable you or your child to have full and equal enjoyment of your home. So this is the most important piece of advice I'm going to give you today, and that is put it in writing. You may have the world's greatest landlord, you may have a jovial homeowners association board, but even if you expect that nothing will go wrong, put it in writing. In this regard, email is the best invention ever because it is a very simple, quick, and unobtrusive way to...
The foundation.
I'm sorry, I hear somebody speaking.
If I want to get that, how much engineering needs to be done on the foundation before I can get that?
Okay, somebody mute. All right. So email, best invention ever. It's great to put everything you do with your landlord in an email. A lot of people text with their landlord or their property manager. That's fine too, but to be honest with you, as a lawyer, if I'm going to try and use it later, it's a lot easier for me to show an email to a judge than to show them a series of texts. It's just harder to put a series of texts in a nice, neat form. So my advice to you is if you have a phone call with your property manager, or if you just run into them in the hallway and you have a quick conversation, document it. Send them an email saying, hey, Joe, just following up on our conversation. It was great to talk to you. And I asked you to have this policy change, and you've told me that you're going to look into it and get back to me. Thanks so much. I look forward to talking to you about it soon. Just something really low key like that. It provides a marker so that if anybody is going back to say what happened in this process, you will have it in writing. So the first question, when you need to approach your landlord or your HOA, is when could I make a request? And the answer is anytime. Anytime. You can make it during the application process, especially if as a result of a disability, you can't fill out an application, or as I said, you need a co-signer on the lease, or you need to pay your rent at a slightly different time. All of those things can be broached during the application process. You can make it when you're paying your rent on any given month. You can make it anytime during your tenancy, and you can even make one when you're moving out. So this slide just emphasizes that reasonable accommodation requests can be requested even if the tenant has already been served with eviction papers. So it says a reasonable accommodation can be lodged up until a judgment is issued and sometimes after. And the regulation says until a landlord makes a good faith, reasonable effort at accommodation upon request, the landlord's continued pursuit of an action for possession is a discriminatory act. All right. So it's a violation. I'm sure everybody probably is aware that it's a violation of the fair housing laws to cover up discrimination by threatening to evict the tenant for advocacy or for requesting a reasonable accommodation. But even if the eviction is a legitimate eviction, a person or family with a disabled member can still get a reasonable accommodation request for that process of eviction. For instance, a delay in a move-out date. So I recently, at the beginning of the pandemic, had a client who was under an order of eviction, and the court had ordered a move-out date. And I worked with that landlord to get a reasonable accommodation because the disabled person is very susceptible to COVID and could not safely move out. And the regulations came in preventing evictions later on a statewide basis. But what we did is we said, we are going to extend the move out date until this pandemic is over. And we have had dates certain, but we keep moving them until it's safe for the disabled tenant to find a new place to live. All right, so what is the process of getting an accommodation from your landlord or your organizing entity? Well, you ask. No particular form is required. And a verbal request is okay, but as I've said, I would much rather see anybody putting it in writing. But a landlord cannot refuse to grant a request that is only stated verbally. And you don't need to use any magic words except to explain the disability related need for the change. This is this concept of the nexus. Because I have a condition which prevents me from climbing stairs, I need to have a ramp. And it's just that simple. So once you make a request for a reasonable accommodation, then the second step is the landlord's response. And the law is very clear. If a request for a reasonable accommodation is reasonable, the landlord must grant it. Period, end of story. The landlord's response must be timely, and it must be a response in good faith. They can't stall, and they can't pretend they're going to grant it just to put it off. If the disability is not apparent, then the landlord may ask the tenant or the requester to verify the fact of a disability. And if the landlord does not think that the request is reasonable, then the landlord has to engage in what the law calls an interactive process, a back and forth, to try and come up with a solution and an accommodation that would be reasonable. So let's talk about what's reasonable. It has to be related to disability, and it has to be necessary to remove a barrier to full and equal enjoyment of your home. So for instance, if you ever thought to yourself, if only I could get a closer parking space, then my life would be so much easier. That is a legitimate and frequently granted reasonable accommodation request. There are only 2 exceptions to a reasonable request not being granted. And one is that it would fundamentally change the nature of the services that the landlord provides. And the other is that it would be an undue administrative or financial burden. And undue, of course, is decided on a case-by-case basis, but the law is very clear that landlords are expected to have to spend some money in order to grant accommodations. Just because it costs them money does not make the request unreasonable. And a court, looking at a landlord's objection to cost, is going to take into account the resources of the landlord. So small landlord, something super expensive might be unreasonable, but a big landlord, or if your building is owned by a real estate investment trust, that they're going to have a very hard time protesting that an accommodation request is unreasonable on the basis of expense or administrative burden. So as part of responding to your reasonable accommodation request, the landlord cannot increase your security deposit, cannot charge money for a policy change, cannot just say no. They can't say no. If they want to say no, they have to engage in this interactive process, which is step 3 we'll talk about. And they cannot at the outset say to you or actually deny you housing because they're afraid you're going to ask for an accommodation at some point. All of those things are forbidden. So talking about my case where the family needed to put an air conditioner on the outside of the building, the child has special needs, and the heat and the air pollution that we've been having in the Bay Area lately was affecting the child's ability to breathe and making them sick. And so the doctor recommended that they put in an air purifier and an air conditioner in their unit. So they made this reasonable accommodation request to the Condo Owners Association for a change in the policy to be able to put something on the outside of the building. So let's break that one down. The request has to be granted. The homeowner has to pay for the installation and the changes to the building to install the system. But the Condo Owners Association has to change its policy to allow the installation, even though other people are not permitted to attach things to the outside of their buildings. And in this case, the Condo Owners Association, in order to grant this exception to the policy, it was their position that they had to employ a lawyer to rewrite the rules and regulations for the Condo Owners Association. Setting aside whether they really did need to rewrite it, they wanted to charge the family for the cost of the lawyer to rewrite the rules, and that is forbidden. And that would have cost maybe a few $100, maybe $1,000. It is not something that the Condo Owners Association could charge the family to do. So what happens if the landlord responds and says, I don't think this is reasonable, I don't have enough information? Well, and then you go to step 3. And this is the interactive process. So this slide just reiterates that the landlord has to grant the accommodation request unless it's an undue burden or a fundamental alteration in the service provided. And it also emphasizes accommodations need not be free of all cost to the landlord. So let's talk about what might be a fundamental alteration or an undue burden. So if you live in a multi-story building, that 2-story building, it doesn't have an elevator, it may not be reasonable to ask them to install an elevator because that requires creating a shaft and it's technically difficult, and hugely expensive even for a very wealthy landlord. But it may be reasonable to add a lift to the stairs so that there's a, one that goes up the railing so that a person with mobility disabilities has access to their unit on the second floor. And that's the kind of process where a landlord could come back and say, I know you've asked us to put in an elevator. We don't think that's reasonable, but what about, and they provide alternative suggestions. They could say, you could say to them, what about a lift? Or you could say, what about a transfer to a first floor unit? Those are alternative accommodations which are reasonable and which do not run afoul of the undue burden limitation on accommodation requests. Similarly, the term fundamental alteration service, what does that really mean? It very rarely arises. It would be a fundamental alteration to ask your landlord to walk your emotional support animal, because the landlord is not pet sitting service, right? That's not their job. What they do is they provide housing. But as so long as what you're asking for is a change to one of their actual policies or is part of providing a housing service, then what you're asking for is not going to constitute a fundamental alteration. So the interactive process is a valid thing for a landlord to ask to engage in. It's important that the person requesting accommodation act in good faith, be open to alternatives, and show that they're willing to have an open discussion. But it's also important that you do not need to settle for something that doesn't work for you just because the landlord says, I'm not doing anything else. So I have a case in which our clients have asked for a parking spot in the garage. Nobody else parks in the garage except employees, but there is room for parking. And because of their severe mobility disabilities, they have asked to be able to park in the garage as a modification of the policy against tenants parking in the garage. And the landlord said, no, we're not going to let you do that, but we will allow you to come into the garage, park for 30 minutes, and then you have to go out again. So this was a landlord's idea of an alternative reasonable accommodation. Well, this family lives in a very dense urban area, and there really isn't parking on the street around them. They sometimes search for parking for 45 minutes before they find something. And in the meantime, they have gone into the garage, they have brought their disabled family member up to the unit, they have come back down, they have left, and the disabled family member is all alone. So this alternative is not reasonable because it doesn't solve the problem of the person with a disability having easy and equal access to their unit. And it doesn't solve the problem of the person with a disability being left alone while the family is out searching for a parking spot. So in this instance, the landlord's interactive process and alternate accommodation request is unreasonable, and the tenant does not have to accept that. All right. Now, this interactive process can take some time, but when I talk about how much time does it take, a period of weeks for most accommodation requests should be entirely sufficient. It should not take months for your landlord to get back to you. And so here it's important to remember that an unreasonable delay is also a violation of the law. It's a form of discrimination to unreasonably stall out the interactive process. Many cases that I've had when we resolve the case, we establish in a policy for the landlord that they have to respond within 10 days, within 15 days. And that is how we make sure that these requests stay on track. When you're doing it for yourself, it is absolutely appropriate to follow up. It's been 3 days, you haven't heard? Follow up in writing. Hi, Joe, the property manager. I'm really looking forward to working with you on this reasonable accommodation request. I sent it to you on the 15th. Today is the 22nd, and I haven't heard. Can you tell me what's happening? And we have to assume that landlords and property managers are acting in good faith and that they have a lot on their plate. They do not always understand how important these accommodations are for our people to be living their lives. That is, and to them, it's sort of one more thing to deal with. It's an administrative hassle, but for us, it's really important. And so we shouldn't be afraid to continue to pursue this and to take action if they keep stalling or putting things off. All right, so here we are on the second MCLE code for you lawyers out there. And this is 7726. MCLE code number 2 is 7726. Okay, let's talk about verifying disability. Now, you may remember a few slides ago, I talked about what can the landlord ask about disability. If the disability is obvious, if you're making a request and you're in a wheelchair or you have, your cochlear implant on the side of your head, they should not ask you any questions about the disability. The slide says if the disability is obvious or known to the housing provider, the provider may not ask for further information. If the disability or need is not obvious, the housing provider can ask for information only to confirm the existence of a disability and to confirm the connection between the disability and the accommodation requested. So for instance, even if a person's disability isn't obvious, but the provider knows their tenant is on SSI or SSDI because that's in the application, then that is an obvious disability and they needn't ask about the nature of the disability. On the other hand, this family who needs the air purifying unit, their child is in a chair, but not all wheelchair users have breathing problems. So it's okay for the landlord to ask for a medical provider or a diagnostician to provide a letter that says the child has a condition which makes her very susceptible to pollution and heat, and therefore they need an air purifier and an air conditioner in their home. Notice that this language does not allow the landlord to ask, what is your diagnosis? So it doesn't matter if the child has cerebral palsy or spinal muscular atrophy. All that matters is the child has a condition that creates breathing problems. All right, so now what we're going to play a game called From the Landlord's Mouth, Real World Scenarios. And I want to give a special thanks to our talented associate, Deborah Gettleman, for inventing this game. We are going to go through things that actual landlords have actually said, and then we're going to talk about whether they're okay or not. All right, so from the landlord's mouth, we won't consider your reasonable accommodation request unless you fill out our form. Is that okay or not okay? Well, it's not okay to demand it in writing as a condition of granting the accommodation, but it is in your best interest. So if they have a form they want you to fill out, super duper. It means they're at least slightly organized about the process of granting reasonable accommodations. So as long as the form itself doesn't ask invasive questions, if it just asks what is your disability related need, then you absolutely, it's in your best interest to go and fill out this form. From the landlord's mouth, in order to grant your request, I'll need you to sign this release so I can contact your doctor directly to verify your disability. Is that okay? Well, maybe. If it is a release for all your medical records, obviously not okay. The landlord does not have a right to your child's diagnosis. It does not have a right to see medical records. It does have a right to have someone verify a disability-related need for an accommodation. So that would be okay. So then that's what this next slide says. In response to a reasonable accommodation request, the landlord can ask to verify that the person has a disability protected by law and describes needed accommodation and shows the nexus between the disability and the accommodation. But again, not if the person's disability and need for an accommodation is obvious. So what kind of verification are we looking for here? Well, a tenant can often provide the verification themselves, especially if they can prove provide proof that they're on disability-related benefits. A medical professional can do it. It does not have to be a doctor. It can be a nurse practitioner. It can be a therapist. Any medical professional. Somebody who runs a peer support group can do it. A social worker can do it. And a non-medical service agency. So if you have some sort of social worker, your social worker can definitely do that. In most cases, an individual's medical records or detailed information about the nature of a person's disability is not necessary for this inquiry. That is a quote from the regulation. All right. From the landlord's mouth, you can move from your studio on the 5th floor to a studio on the 1st floor to accommodate your disability, but you have to pay the difference in rent or an additional deposit. Is this okay? Probably not. Probably not okay to charge more. The landlord will probably argue it's an undue burden, but the rent should remain the same, absent compelling facts. So we had a case where our client was a veteran and had PTSD. And his landlord started doing construction work in the building right underneath the tenants with PTSD's apartment. And it sounded like being in a war zone, and it was completely triggering the tenant's PTSD. And so the tenant asked to be moved to a different apartment away from the noise. And there weren't any apartments available that were the same size as what they rented, but there were some larger apartments available. And federal judge ordered the landlord to move that tenant to a larger unit at the same rent as an accommodation of that tenant's disability. So it's always going to be on a case-by-case basis, but if your landlord starts talking about charging you more for an accommodation, you should be very suspicious, and you should be very careful about just agreeing to that. All right. Now we're going to switch gears, and we're going to talk about questions that many, many people have about animals in housing. And this slide has a picture of a golden lab on it with a little service vest and a little leash around its muzzle. And we're going to start by talking about what are the terms that people use for animals that provide assistance to people with disabilities. And so this next slide says terms to confuse or unconfuse folks. It has a picture of a photograph of a Saint Bernard and a couple of smaller dogs and a rabbit and 2 cats, and a parakeet is standing on the Saint Bernard's back, and there's also a little mouse. And this slide has a list of the kinds of terms that people use to describe animals that help people with disabilities. The first term that most people are familiar with is service animals, but the term service animal has a really specific meaning under the Americans with Disabilities Act, and that is an animal, either a dog or in some rare cases, a miniature horse that is specifically trained to perform a task for the person with a disability. The dog is trained for this one individual, and it does something related to that person's disability. The second term that you'll hear a lot is emotional support animal. And the distinction between a service animal and an emotional support animal is twofold. One, any animal can be an emotional support animal. It does not have to be a dog. And unlike a trained service animal, an emotional support animal ameliorates the person's condition by its very presence. So these folks who have diagnosed conditions for anxiety, depression, those sorts of things, the presence of their animal ameliorates their medical condition. The third kind of category you sometimes hear thrown about is therapy animals. A therapy animal is specifically used in a healthcare milieu. It's the dog that goes to the hospital and meets the patients. It's not tied to any one individual. Its handler is not a person with a disability, but it goes out and it helps people with disabilities, maybe in a group therapy session or some other therapeutic situation. The fourth kind of term that people sometimes use is comfort animals. And this is not a thing. That is what the slide says. It says comfort animals are not a thing. This is not an official term. Although it's used a lot, it doesn't have any legal meaning. And it can be confusing because many animals provide comfort in many different ways. It doesn't necessarily mean that they're not a pet. So I really try to avoid that term. The Department of Housing and Urban Development is the federal agency that issues the regulations for fair housing primarily. And so it uses the term assistance animal. I really like this term because an assistance animal incorporates both the service animal, which is specifically trained dog, and an emotional support animal. So either one of those two terms would be considered by under the fair housing rules to be an assistant animal that is permitted to be in housing. That is a lot of information to dump on people. I'm happy to give more examples in the question and answer in session or at another time. But for the purpose of this webinar, we're going to talk about assistance animals, and we're going to mean both service animals and emotional support animals. Oh, here we are on the third MCLE code, which is 9821. 9821. Okay, so we talked about service animals. They're specifically trained dogs. They do a specific task or tasks for the person with a disability. They can go anywhere that a person with a disability can go. And although this isn't about housing, I want to emphasize that service dogs can go into hospitals unless it's a sterile environment. They can go into locked psychiatric wards. They can go into restaurants and grocery stores. They can go into transportation, and they absolutely can go into housing. Emotional support animals, and this slide shows a photograph of a person sitting on the grass and wearing a white shirt and a black watch and a necklace and an earring, and sitting with their dog between their knees, their German Shepherd wearing a vest, and the person has a bald head, and the dog and the person are looking into each other's eyes. An emotional support animal is scientific. It's scientifically shown that support animals can ameliorate psychiatric disabilities. And that's why they're allowed in housing. And that's why it doesn't have to be a dog. I know the lawyer who brought the emotional support dog case that was written about in the New York Times. An emotional support duck is a legitimate emotional support animal. But emotional support animals are only allowed at home and on airplanes. They have a limited scope because they are not individually trained, and so there is no task training required for them. But they are allowed in housing. So when we go to the next slide, which says, how does all this apply to housing? We have a picture of someone in front of a building next to a lawn. They're kneeling down, they're wearing a maroon shirt, they have short hair and sideburns, and they have next to them a dog, which could be a mutt or a Staffordshire Terrier. It's kind of a beige color with a white patch on its chest, and the person and the dog are giving each other kisses. So how does all this apply to housing? To reiterate, all assistance animals are protected under the fair housing laws. Okay, even if your landlord has a policy explicitly prohibiting pets, they have to allow your emotional support animal or your service dog. They are required to make an exception to the no pet policy. And here there are two documents that the government has issued, one from the Housing and Urban Development and one from the Department of Justice, that talks about the distinctions between service animals and emotional support animals. You can look those up and show them to your landlord if you need to. All right, the next slide says breed does not matter. So this is a very common question. Does it matter if I have a duck or a dog, or does it matter what kind of dog I have? This slide shows a photograph of a big old handsome pit bull with a person wearing a Christmas sweater and sitting on a bench, and the person has the dog's lead in one hand and his sort of arm around the dog in the other hand. And this is a beautiful velvety gray pit bull with a white patches on its feet and on its head. I'm wearing a turquoise collar and its big old tongue hanging out and its eyes half closed. It's a very happy dog. So so this is to remind us that it doesn't matter if it's a pit bull. The only question is, how is this dog behaving? A dog can be excluded, or any animal can be excluded from housing if it creates a direct threat to the safety of other people. The direct threat to health and safety cannot be based on assumptions or on fears, and it means individualized assessment means look at the animal. You can't tell unless you see the animal whether this dog is going to present any kind of threat. The dog or animal should be healthy, not flea-ridden, should be well-behaved and under control, has to be leashed unless it's a service animal and the leash interferes with the tasks it performs, and the handler is responsible to clean up after the animal. Sanitation is critical. So if you have a support animal or a service animal, please be a good owner and be a good neighbor, because it helps to reduce the stigma associated with emotional support animals and service dogs, but also because not taking care of your pet is a good way for a landlord to have a legitimate reason to exclude it. All right. Next slide says no to fees, but yes to costs. A landlord cannot require a pet deposit for assistance animals, even if it charges a pet deposit to other tenants. But the housing provider can charge the individual for the cost of repairing damage if the provider regularly charges tenants for other kinds of damage they cause to the premises. And I don't know any landlord who doesn't charge the tenant for damage they cause. So you have to be prepared to pay for that if your dog or your cat or your bird does something that harms the premises. So back to our game from the landlord's mouth. The landlord says to you, you didn't tell me you needed or had an emotional support animal when you moved in, so you can't have one now. Is that okay? No. A reasonable accommodation request can be made at any time. And there is a published case that says that a homeowners association discriminated against the tenant by denying a reasonable accommodation for an emotional support animal, despite the fact that they made the request after they had acquired the animal. That's this next slide says exactly those things. So if you can, give advance notice. Be a good neighbor, be a good tenant. But having an emotional support animal is your right. All right, from the landlord's mouth, I'll approve an emotional support animal, but absolutely no pit bulls. Is this okay? No, it's not okay. There are some cities that purport to prohibit certain breeds of dogs. There are some landlords who say, I'd allow your pit bull, but my insurance company won't let me. It prohibits me from having pit bulls on the property. Those are not legitimate excuses when it comes to an emotional support or service dog. Breed size and weight limitations may not be applied. The idea that a dog or an animal poses a direct threat of harm has to be based on the specific animal's conduct and not speculation about breed. All right, the landlord says, if you're going to bring in an emotional support animal, then you have to pay an additional deposit or pet rent. Absolutely not okay. And that's what this next slide says. So if a landlord says to you, well, I'll approve your reasonable accommodation request, but first I need to see their service animal certification, that is not okay. No law requires an assistance animal to be certified, for very good reasons. Because for an emotional support animal, there's really nothing to certify. There's no training required for that dog. If a dog is a service animal, then it's okay for a landlord or anyone else to ask what task is it trained to perform. So it would be appropriate for them to say, well, you say that you have a hearing dog. What does your hearing dog do? And then you would answer, well, my hearing dog alerts me when there's someone behind me. They let me know when the tea kettle is whistling, and they let me know when someone's knocking at the door. And that's all that the landlord can ask about. When the ADA was passed and the Department of Justice was issuing regulations, it very explicitly considered this question of whether or not to create a certification for service dogs. And it rejected the idea. It took a lot of public comment, and the reasons that it decided not to require certification is that it's very expensive to get a truly certified service dog. In other words, it's very expensive to go to a nonprofit or an organization that trains service dogs and get one. It can cost, well, I've seen it range from $25,000 to $50,000 for one of those dogs that comes pre-certified. And most people with disabilities simply can't afford it, and they shouldn't be required to. There's also a big shortage of that kind of professionally trained dog. And so the Department of Justice determined that people should be allowed to train their own service dog. It's certainly possible. And it's not that difficult to train a well-trained dog to perform specific tasks. So in that instance, there really is no organization that can perform a certification, especially since the tasks that service dogs perform are so varied. It's really difficult to come up with one certification for all the possible things a service dog can do. And in addition, it's really easy to forge those kinds of certifications. Any one of us could go on the web right now, Google service dog certification, and for $15, someone will sell you a vest, or they will sell you a certification card, regardless of your dog, regardless of whether it really is trained or not. And so the Department of Justice was thinking, well, people are going to spend all their time trying to chase around and find out if this is a real certification or fraudulent certification. So they decided it was best, with the goal of having as many people have access to service animals as possible, it was best not to have a certification. Now, I know there are also government entities which purport to provide a certification. The Alameda County Sheriff's Department actually will certify your dog. They, of course, are going to require a little more information, and they will provide, you have to answer questions what the dog does. They'll provide you with a certificate. Fabulous. They'll provide you with a little dog collar that says service animal. Terrific. Can your landlord ask you for that information to prove that you have a service animal? No, they just can't do it. So if your landlord says to you, I want you to provide me proof that your animal is a service dog, or proof your animal is an emotional support animal, there's nothing for you to give them, and it's unreasonable for them to ask. The one caveat to that is that if you want to have an emotional support animal, most of the time, the disability for which an emotional support animal is needed is not obvious. And so it is okay for your landlord to ask for verification, to ask your therapist or somebody to write a note saying, my client is a person who has a condition for which an emotional support animal ameliorates the symptoms. And therefore, I recommend that he or she have an emotional support animal. They don't have to say, my client is terribly depressed. In fact, I would hope that they wouldn't say that. I would just hope they say, I have a condition for which an emotional support animal is valuable. Please allow them to have an emotional support animal. This kind of thing is very clear in the law. People get a lot of runaround from their landlords because landlords have legitimate concerns about wear and tear on the property and other tenants who are afraid of dogs. All of those things can be worked out. But the important thing is to remember that if, as a person with a disability, you and your family have the right to have equal access to your home and equal enjoyment of your home. And if an emotional support animal is what it takes in order to provide you with calm and to ameliorate your symptoms, then you have the absolute right to have an emotional support animal that you take care of and that doesn't cause problems in the unit. Okay, so that was an overview of the rights available to you. I'm going to take questions, but before I do that, I want to talk a little bit about how a person goes about enforcing these fair housing laws, because you can do everything right. You can put it in writing, you can engage in the interactive process, and act in good faith, and regrettably, sometimes the landlords just will not do the right thing. So what do you do then? You're not helpless. There is assistance out there. And you have a range of options of what you can do. The first thing is there are two fair housing agencies that you can complain to. In California, the Department of Fair Employment and Housing, and the federal level, the Department of Housing and Urban Development. Both of those will accept claims of violation of discrimination based on disability. You have to file these claims within a year of experiencing the discrimination. And I have the phone number and the website here on this slide. The folks that work in these units are really good people with really good intent, and they're very overwhelmed. Unfortunately, there's a lot of discrimination happening. So my experience with these is that they're very slow. It can take a year or more to resolve, but they will help assist most people to mediate with their landlord. And by mediation, what I mean is they will facilitate a conversation to see if the landlord and the tenant can mutually agree on a resolution. They will not necessarily be an arbitrator and tell the landlord, you've got to do that. They take very few cases where they will represent a person who's a victim of discrimination, just because they can't take every case. So if you decide to put in a complaint to one of these agencies, then it's really important that you follow up, that you ask to speak to the investigator directly, and that in turn, you are very responsive when they ask you for information, because they are, of course, going to be motivated to help the people who are cooperating with them. In an eviction, you can raise discrimination as a defense or a counterclaim. On the next slide, I have a list of agencies, including people who help with evictions. And you absolutely should let your advocate know if you're in an eviction situation, if it's related to your disability, because that will help them help you. There are a number of community agencies you can contact for assistance, and then you have the option to file a lawsuit in state court or in federal court. Generally speaking, you have to file your lawsuit within 2 years of the most recent act of discrimination. I'm a lawyer. I litigate, and so I have a bias in favor of filing lawsuits. And I will tell you why I like a lawsuit. Because you can ask the judge to stop the landlord from discriminating, or ask the judge to order the landlord to do something affirmative to modify its policies, to install accessible features. You can get damages for the discrimination you have experienced. And if you prevail, you can get an order from the judge that the defendant has to pay your attorney's fees. Most lawyers who do housing discrimination will take a case on a contingency basis, meaning that they don't require their client to pay up front the hourly fees or the cost of the litigation. They will take a case because they think they can win it, and at the end of the case, they will ask the defendant to pay their reasonable fees. This system is good for a lot of reasons. One, people who don't like big government, this allows the market to take care of enabling enforcement of the housing rights laws without having a big bureaucracy. It's true that most landlords have more resources than most tenants. So most tenants could not afford to vindicate their rights if they had to pay their lawyer by the hour up front. And frankly, just as a question of justice, the idea of having the malfeasor, the bad guy, or the person who made a mistake pay for their mistake, it's an incentive not to discriminate. And I think it's what gets the attention of a lot of landlords, to be honest. So every person knows what's right for them on how they want to approach enforcing their rights to fair housing. And this slide shows that you have, at least 3 or 4 different options for doing it. If you want assistance, here is a slide that shows community resources. The first 2 entities on this list, and I have the websites here listed, are Disability Rights California and the Disability Rights Law Center. These are 2 of the biggest generalized nonprofits that have the sole purpose of assisting people with disabilities, and they both do fair housing protection work. You could go to your local legal aid organization. Legal aid is, again, a very broad kind of nonprofit. They do many kinds of work on behalf of the public, like consumer protection and that kind of thing, but they all, or most of them, have a landlord-tenant unit. And any of their landlord-tenant attorneys or advocates are going to understand how to approach a case when the tenant has a disability. And this website here will link you to just an enormous list of legal aid entities, and you can search by location. And then finally, there's an organization that I really like called Project Sentinel. And this is a fair housing organization. They do all sorts of landlord-tenant work, but they're really good at disability rights work. And I think they're mostly located in Northern California. You can find all their locations on this website, but they're also good at giving out advice over the phone. So those are your options. Or if you have questions, you can call me. I am happy to help out. And these days, things are super busy in the housing discrimination area. So probably the most efficient way to reach me is by my email, which is here, but you're welcome to call. You can look at our Facebook page, or you can look at our website. And I think it's time for me to take questions, but I want to thank you for your patience listening to me all the way through this process. I hope it helps.
Well, that was outstanding. And I have to say, Celia, I especially loved the example. So you just didn't run through all the laws and that kind of thing. Really enjoyed the examples. By the way, I want to mention this real quick as we plow through as many of these questions as we can. The recording should be available, assuming that something doesn't screw up here. And if it doesn't, well, nobody's going to see it anyway here. So it will be, and we really want to encourage folks to share this information with other advocates that could benefit from this. The other part of this is accredited by the State Bar of California. We are an accredited provider for not only for attorneys, but also for private fiduciaries. And I have to say, if you're hiring an attorney, like a special needs attorney or a fiduciary, if they went through the time to learn about these things, isn't that the kind of person you want working with you, who digs a little deeper into the rights of folks here beyond just, preservation of benefits? With that in mind, okay, we have one, and I know you answered a lot of this, but here, and this is from KT here, who wrote quite a little dissertation, but let me break this down, okay? She has a daughter who has significant breathing issues, okay, here, and she's in an apartment here where half of it is vinyl flooring, and the other half is wall-to-wall carpet here. And the problem with it is it's difficult to clean here, and also it harbors dust mites and that sort of thing, which directly interferes with her daughter's needs here. So it's kind of a compound question here. Is it appropriate to ask for an accommodation to change out the carpet here? And I think one of the things with it is, and who pays for it? Mm-hmm. By the way, carpet and disability, that's things that usually don't work well together, but there you go.
My whole living space is wood floors. So the answer, KT, is absolutely appropriate to ask them to switch out the carpet for a smoother flooring that's wheelchair friendly. Who pays for it will depend on what kind of housing you live in. If you live in federally funded housing, then likely the landlord will have to pay for it. If you don't, likely the burden will be on you to pay for it. And the landlord will have the right to sort of oversee what you choose, and to make sure that you have a contractor who is qualified so that nothing about the unit gets hurt in the process of changing it out. Unfortunately, if you're the one who has to pay for it, you also have the legal obligation to pay to have it removed if the landlord demands that you do so at the end of your tenancy. So if you're calculating the cost, calculate the upfront cost, and also calculate the cost of taking it out and putting the carpet back in. Frankly, many landlords change out the carpet in between tenants anyway, so that's definitely a point I would negotiate with your landlord. But my advice would be to approach your landlord with some estimates in hand, and a plan. Say, this is what we want to do. This is what it'll cost. Here's my contractor who is fully licensed, and see what they have to say.
Now, just kind of a follow-up on that here, trying to pull information out of this question. So what if the other units, the landlord is replacing the carpet anyway? Would it be appropriate for them to say, well, look, you're replacing the carpet for everybody else, don't charge me, and could you just kind of move us up to the top of the list as an accommodation?
Oh, those are both great ideas. If a landlord's in the process or has the custom and habit of changing out flooring for new tenants, if you're moving in, you could ask for that at the time of move-in, or you could say you're going to be doing it anyway at some point in my tenancy because you change the carpet every 3 years or something. I think it would be appropriate for you to pay for it since every other tenant gets it paid for. And also, Steve, your idea of moving to the top of the list, that I really appreciate you mentioning that, because asking for priority is also a reasonable accommodation, because it's not just something that is, aesthetic, or my carpet looks worn and I'm worried what will my dinner guests think. This is really something that is essential for your daughter to use and fully enjoy her home. And so you should have the right to ask for priority as a reasonable accommodation.
Okay. And then, sometimes you read these things and you think, well, how odd is this, until you're actually in the situation of this person. So here's a question I've never heard before related to this. Here is that in that apartment is a gas stove. Okay, now sometimes it's hard to light, but the more relevant here is that our person with a disability living in the home cannot smell or doesn't hear the clicking of the burner and wouldn't smell the gas. And the problem is, I guess, that they concerned that we don't want to blow up our person with a disability. Would it be appropriate to ask for an electric stove as a replacement?
Oh, absolutely. And I would alert the landlord that this, is potentially going to be an expensive problem if the apartment gets blown up, and so it should be done right away. And I would at least advocate for the landlord to pay for that. I can't say as a matter of law you're entitled to it, but the landlord should see it's in their best interest for sure.
And I know, Celia, you had covered, and this is the last part of this series here, but in this case, and why don't we go a little bit beyond the question? In this case, they're more than willing to pay for the installation and these different items and all that. What they don't want to do is be responsible for upkeep or repair or a future replacement in the future. Here, so let's go with the electric stove. They put in the electric stove. There's a problem with the electric stove. Who pays for the repairs?
I think that the answer to that question depends on what the current policy is and what the lease says. If the lease says that the landlord will make repairs, then the landlord should repair the electric stove, because that's a service that the landlord provides to everybody. And the fact that you have a different kind of stove because of your disability doesn't change that. In fact, there are a lot of leases that prohibit you from doing anything but calling your landlord for repair. And so certainly the landlord should not be expecting the disabled person to take on a greater burden than able-bodied tenants have.
Now, working through this, by the way, the webinar is officially over, but we have a ton of questions here. This does not surprise me.
I am here for as long as people have questions.
Well, that's a dangerous thing to say, so we're going to go with that. Okay, so here we have From an anonymous attendee. By the way, I'm only going to use your initials. So, have there been any recent changes to disproportionate impact rules?
So there is a concept. I want to make sure I understand the question. There is a concept in disability discrimination law about disparate impact, meaning that a facially neutral policy has a discriminatory impact on a group of people because of their disability. So if that's the concept that the question's asking about, I don't know about changes in the fair housing law, but it's very clear that disparate impact is a form of discrimination that is prohibited. So that if you have your facially neutral policy and because of it, life is more difficult for a disabled tenant, then that facially neutral policy is discriminatory and needs to be changed.
Here's a question from HT here. What about the situation where a person with a disability on SSI is priced out of a building due to rent increases in a building that's supposed to cater to low impact tenants?
So if this is a building that that bases the rent on income because it is either public housing or something like that, then what we're really talking about is whether the calculation of the rent based on this individual's income is fair or not. That is outside my expertise. I know nothing about those admittedly very complicated calculations that housing authorities make and buildings that have below market rent obligations make to decide what is the correct rent.
I was going to say, Celia, if this was posed to me, quite frankly, in a lot of these cases, I've had a very hard time finding an agency or an attorney or a group that could help. Now, I will tell the folks that are watching, if you have a program that works with folks, because I can imagine this is a real issue, who deal with issues, especially dealing with housing authorities and that kind of thing that represent folks, for God's sake, email steve@dalelawfirm.com, because I would love to fill their plate. I mean, that's really difficult. There is no academy of housing authority attorneys that I know of. It doesn't seem to exist. And I think that this oftentimes is a underserved population. So,
you know, where I would send somebody, because I agree with you, I don't have anybody that I can say, wow, here's the ultimate expert in this. I would send someone really to a landlord tenant organization like Legal Aid, because their lawyers have an astonishing breadth of knowledge. And I can't say they don't know. I just can't say I know somebody who does.
So SM here, how do assistance animals policies apply in shared housing environments? For example, a house being rented out to a family or a tenant paying rent for a room in a house with a shared space. That's interesting.
My first question would be to make sure that the fair housing laws apply. Because if somebody is renting a single family dwelling and they're renting individualized rooms, there's an exception called the Mrs. Murphy exception, which sort of envisions this little old lady who runs a boarding house. And not all the fair housing laws will apply in that situation. If it is a commercial venture where the landlord owns 3 or more single family homes, and there's somebody who has the master lease and then everybody is subletting from that master lease, then the fair housing laws probably apply. And in the fact that it is a shared space is not grounds for excluding the emotional support animal. Some people say, well, I don't want a dog in my house because I have allergies. If the allergy rose to the level of a true disability, which substantially affected a major life activity, and we so basically had dueling disabilities, then the landlord would be responsible for coming up with a solution. And to be honest, I wouldn't know what that solution would be without knowing all the facts. But if somebody just doesn't like dogs or it makes their nose a little itchy, that is not a reason to exclude an emotional support animal, whatever the structure of the dwelling unit is. So I kind of answered around that. I hope I answered the question.
No, I think sometimes these things aren't as cut as dry as you'd like, but I think that gives us a lot of guidance here. Now this is kind of a repeat, but let's do this anyway. SM is asking here, who can approve an emotional support animal since they do not have any training therapist or doctor here? So I know you covered that, but.
Well, if you have an animal that you consider your emotional support animal, and you ask for a reasonable accommodation to have this animal in your home, your landlord has the right to ask for verification of the disability-related need for the animal. So I would, in that case, urge you to go to a medical provider, a therapist, a social worker, somebody who can interview you, assess the need and the disability-related need, and verify it. Because if you say to your landlord, I have this need, but I cannot document it, you may have difficulty enforcing it.
Then HT is asking here, and once again, you can tell from the questions that these support animals are so important here. Can a landlord request a letter from a medical provider stating that the tenant requires ESA, assuming an emotional support animal?
They cannot demand it be from a medical provider if there is a letter from another qualified person under the statute. And so it's much broader than just MDs. It can involve therapists, social workers. Like I said, if you're in some sort of support group, and that person knows you and is able to certify, any one of those kinds of people can verify. But the landlord, if your disability isn't obvious, the landlord has a right to ask for verification of the disability-related need.
Okay, moving to something else. BF here says, my single mother makes less than median income, and she is the guardian to my older sister who has intellectual and developmental disabilities, who's on SSI, SSDI. What resources for housing rights should I know about when looking to find a permanent home for them in Northern California here, and has been around for 20 years? That's a good question.
Well, that's a great question. I can help out with issues about knowing what your rights are when you apply. I can't help you find affordable housing. It's a nightmare. And that's all I can say about that. But when your family is applying, the landlord can't discriminate based on the fact that the sister with intellectual developmental disabilities receives public benefits. And if the family needs accommodations as part of the application process, or to live in the apartment equally, then the landlord can't discriminate on those bases. The landlord doesn't have to lower the rents for a person with a disability unless it's part of some sort of program that structures below market housing.
KS here, this is something in a way near and dear to me. If we were to buy a residential property and offer it as a supported living home for a neurodiverse adult, can the surrounding neighborhoods and community object to it? Well, you can't stop them from objecting, but I'll just add, for a number of years, I worked with a program that provided residential programs for folks with developmental disabilities, and we learned the hard way, don't ask the neighborhood beforehand. We would just pop up, and now we're your neighbors. And by the way, they would initially object, and then the problem I had was you couldn't get them out of the house because they would constantly be visiting because our folks were such good neighbors. But but we go back to this. Besides that, if we have a residential property that's been provided privately, it's supported for folks with neurodiverse adults, what can the neighbors do?
I firmly endorse your advice that it is better to apologize later than ask permission up front. Do not tell the neighbors. Just go ahead and do it. So what would the neighbors maybe do is they might go to the city and say, this isn't zoned right. We have all these fears. The question really is going to be about what is the city's obligation, because and the zoning laws, this starts to edge outside of my expertise. But I would say as a general principle, a zoning law that prohibited a supportive living home, I would look at that very carefully to see if it was somehow discriminatory. There are cities that they don't want to zone anything but single family homes for one, with one family, everybody related to each other, because they have perceptions about the value of their homes going down if they do anything differently. So if you run into a zoning problem, you really should talk to an attorney about it to see if it is discriminatory or not. And the only real recourse neighbors have is to go to the city and try and stop it through the regulatory process.
Although you're probably not going to have a lot of zoning rules that say disabled people need not a.
No, no, they're gonna come up with fancier ways to do it.
Okay. Okay, then, and by the way, we're plowing through this. I'm going to do as many as I can. For those of you who have been watching this for credit, we're going to accredit this for an hour and a half. And so if you have to move on, the recording will be available. So I do give you permission to leave, but I'm learning something. So MG is asking us, where can I find out what accommodations are necessary for a person who's deaf? Also in the autism spectrum, but functions with public transportation. He's in a group home now, but interested in an apartment. Now, it would occur to me that if this is a regional center client, that might be one place to get started, although they have their limitations. Celia, thoughts?
Sure. Yes, I think that the regional center should be able to help look for housing and provide vouchers for independent living services in the context of housing. But from my area of expertise, I can say that, obviously a landlord should not exclude a tenant based on their diagnoses, and the tenant can absolutely ask the landlord to install visible alarms for fire safety, for the doorbell, anything that they need to be able to live independently in their home. The question will be who pays for it, but the right to have those things, if a unit is not set up for living as a deaf person, then the unit can be made to accommodate and to be accessible to a person who's deaf.
Okay. And A for anonymous attendee here, what options does a tenant have that lives in a large apartment complex have to get an accessible spot adjacent or in front of their unit? Tenant watched building management install handicap parking spots in other areas away from her apartment and asked if they could install one for her. They completed the work without honoring the request. She needs an agency to contact or resolve. So part of it is the question, but is there an agency that needs to act or resolve?
in terms of, you know, the government building department, you know, of the city this person lives in, probably not the right place to go. I think at this point you need to have an advocate. So I would urge you to go to one of the legal aid or nonprofits or find a private attorney, because this should be a pretty cut and dried request. It's examples of accommodating parking by striping accessible parking spaces for tenants abound in the case law and in the regulations. So if you have it in writing, then I would go ahead and contact one of these nonprofits or a lawyer. If you don't have it in writing yet, I would put it in writing and send an email that says, hi, Jane, property manager. As you recall, I ran into you in the parking lot when you were restriping the parking, and I asked, could you, as long as you're restriping, restripe me this handicap spot? And I never got a response, and I see they're finished doing the parking and they haven't done it. So I'm following up with you. And then when you get a response, or if you get no response, then you take that writing to a lawyer.
Okay. The next one we have here, and I'll just interject, when I was an intern at Dredif doing support for this kind of work, oftentimes we would get involved in what we would call a reasonable accommodation situation. Sometimes in the dialogue, you might actually come up with answers you never thought of here. So it's not always hit them over the head with a lawsuit, although we certainly did here. So here's kind of an example of something, a comment somebody made here for the deaf adult above. Here, and I'm assuming that we're talking about the potential apartment that could blow up from the gas. Here, you might want to put in visual flashing fire alarm installations. You might want to put doorbell alerts. I know more and more that there are alerts that will detect gases and things like that. So they're saying, well, what about that?
Those are all great options. And you know who might be a good resource for that is the Centers for Independent Living. They are usually up to date on the very latest technology. And you can go to them and say, I'm going to be living independently. What do you recommend that I have? They'll provide you a list. You can show it to your landlord, and you and your landlord can have a conversation about what's reasonable and appropriate for the given situation that you're living in.
I know that I was just an intern, nothing more. But when I was an intern at Dredif, it seemed to me like 50% of the landlords kind of dug in and said, what can we do to help, and how can we make this work? And the others were, I'm trying to think what term I can use. They weren't so nice here. But sometimes the landlords will surprise you. They're people. Mostly.
Right. And okay. Some of them, I mean, the amazing thing about the disabled community is you find it everywhere. There are landlords with disabilities and landlords who love people with disabilities, and very often they may be highly educated already. You shouldn't be afraid to ask the questions and to understand that the landlord may just need more information to understand what your needs are. There are plenty of great landlords out there. It's just that, in my line of work, I tend to talk about the ones who are not cooperating.
For those of you that are watching this and going, are they ever going to stop? We're going to stop in 12 minutes. But let's, because I'm having a hard time keeping up as you guys are very inquisitive here. But let's keep plowing through this. Can you give an example of how a landlord should accommodate a modification needed for support staff or live-in staff? Oh, that's a good one.
So this happens pretty frequently if a person lives alone, except that they have a live-in aid. And so they need a 2-bedroom unit, but for instance, they're in a building with below market rental obligations, and they would only qualify for a 1-bedroom unit because of their income or because of the occupancy regulations that are set up. That is absolutely a reasonable accommodation. If you need someone to live with you, even if it's in a studio apartment, that is an accommodation your landlord should make. That should not be unreasonable. And you shouldn't have to pay extra utilities or anything in order to have a live-in aid that's necessary for your disability.
Okay. And then this is going to be a cryptic message to Amy. We have somebody who didn't hear the third code, and I don't want to go back through the program. So Amy, if you could figure out what that code is and send it in chat. Here, I'll repeat it, or you can watch it in the chat. Let's continue here. I think we're getting pretty close, and I understand that Mrs. Dale has lunch waiting for me too. But we have a follow-up about the home and the community. That the question is about that they're forming a SLS home, which would be a supported living services home, I assume. In a residential area, and through health and safety, even a licensed residential facility with up to 6 beds is considered a residential use and can be formed into a single family home parcel. And there's a long explanation there. So Cam, thank you for that information. Okay, we have a few on chat, and then we can all go to lunch here. Here's one that I hear here. Is how do you prove your dog is an emotional support dog and not just a pet? The concern is people that are gaming the system, right? And I don't know that answer to you.
Well, yeah, I mean, we all have to act in good faith and sort of take things at face value. If a landlord is concerned because the person's disability is not obvious and they say they need an emotional support animal, then they can ask for verification from a therapist, from a social worker, from a doctor. And once they receive that verification, that's the end of the discussion for the landlord. They need to accept that at face value.
Okay. How can I investigate the age of the carpet? Carpet and disability, that's a whole issue. In my apartment, the carpet is so old that all stretchers and all that, and it's deformed every time you pass over the vacuum. Now, RG, who's asking the question, is that related to the disability, or is that just a landlord that really should replace the carpet?
That's exactly right. That the takeaway, besides put it in writing, the other takeaway that I'd like everybody to remember when they go out into the world is you need to establish a link between your disability and the requested accommodation. What's your disability related need for new carpet? I use a cane and I am always tripping over my carpet because it bulges up because it's all stretched out. Disability related need. My carpet is really worn and filthy and I can't get it clean. I don't like it aesthetically. I'd like it replaced. That's a landlord-tenant issue, but not a disability issue.
Okay. And then I'm going to do this one time. I'm going to repeat the last code. I'm not going to repeat the other codes here, only because we have to be a little on the zealous side here so that we can keep our accreditation. The last code was 9821. The rest of this, no, we're not going to repeat all the codes because otherwise you wouldn't have to listen to this wonderful presentation. Oddly enough, here, okay, there's one more, and then at that, kids, we got to put an end to this. Okay, we could do this all day, but should PG&E be giving a low-income discount to individuals on SSI? Well, without reading the question further, yes, but I don't know if they have to, who have a live-in aid. Okay. They keep questioning income of approved live-in aid because the aid at present is a parent. Interesting.
Oh, that is very interesting.
Yeah.
That's a tricky one. I don't know the rules or the regulations around PG&E. It's very highly regulated. I don't know what parameters the PUC is giving them or the state. It's sort of interesting. The way I would characterize the question is, can you include the income of an aid in assessing a disabled person's right to have a reduced utilities fee? And my gut reaction to that would be, no, you cannot. And then the PG&E is saying, well, it's not really, they're not there as an aide, they're there as a parent. I think that's a really interesting question. I think PG&E should get over itself and give them the reduced rate.
I like that answer. I like that answer. Okay. Anyway, we could do this all day and all that, but a couple of thoughts as we finish up, Celia, and then is that first off, I know a lot of attorneys who do the work that you here in Derby, McGuinness, and Goldsmith do here have been under attack for quite some time. I have to tell you that I know the way the law was set up, it was set up so that people could enforce their rights privately. And I remember when I was working with DREDF, the big push was that people were their own private attorney generals, because once again, it's just not one of these things where the AG is going to do it. I mean, for all of us, we need to support law offices that do the incredible work you do, because if we don't have enforcement of our laws, well, what's the point here, especially for this very vulnerable population? So first off, I want to thank you for the wonderful work that you guys do here. With that, any last thoughts, words of wisdom, anything along?
Don't be afraid to stand up for yourself. You can find someone to be an advocate for you. You have the right to live freely, equally, and comfortably in your home. And so don't give up.
And I think that's a great place to end on. Once again, I want to thank you guys for watching. If you're a private fiduciary or an attorney, here, once again, go to gspt.org, where it says attorney resources. Look way at the bottom of the MCLE list portion, and download the form if you're looking for credit. If you just can't do that, we'll make a reasonable accommodation for you. Just email Amy, AMY, at gspt.org. Also, when you do that, visit some of our other programs that we've done. We do these on a pretty regular basis here. Even though these are accredited for professionals, don't tell anybody, but we kind of dumb it down for the attorneys here. This is something that you should be able to follow here. And with that, I want to thank you, Celia, and happy advocating.
Bye, folks.